Although I have been somewhat critical of the tactics and to the extent that it's relevant, the strategy of defense counsel in the Edric Faust case, here's how you know the defense in that case is doing a decent job of defending the man. The prosecution is responding to the defense instead of the other way around. Let's talk about that. Hi, Tony DeWitt here, Missouri appellate attorney, retired, and a guy who likes to make the law make sense on YouTube. This is what we're talking about today. This is the murder trial of Edric Faust. He's accused of killing University of Georgia law student Tara Baker in 2001. After more than 2 decades as a cold case, Faust was arrested in 2024 after DNA testing linked him to the crime. Opening statements began last week in Athens in Superior Court. Prosecutors say Baker was essayed, strangled, stabbed, and left in her off-campus apartment, which was then intentionally set on fire to destroy evidence. The prosecution is presenting forensic evidence and witness testimony, including neighbors who reported seeing a suspicious person near the scene. Defense counsel continue to rehabilitate their client's case by challenging the evidence's reliability, and they have clashed consistently with the judge over courtroom conduct. Yesterday, I did a video where I showed that defense counsel, Mr. Cruz, was essentially impeaching the boyfriend, Chris Melton, with information that was not particularly material. In other words, things that in the long term would not really matter. Now, Melton's explanations for why he did not remember things were actually pretty cogent. You have to remember this is 2001 when this occurred, and it's 2026 now. Been a long time, right? And so, to give you an idea of why I think it's pretty reasonable for him to have forgotten some stuff, I would bet that almost any one of you, unless you eat the same thing for lunch every day of the week, you couldn't tell me what you had for lunch on January 3rd, 2021, unless it, for some reason was your birthday or your mom's birthday or some other major event in your life happened on that day to make that day more memorable. The human brain has a fairly large capacity for memory. We can all remember things that happened to us as children, as well as many things that have happened to us as adults. But for 13 years, I took care of patients in hospitals in Florida, Missouri, Illinois, Ohio. If someone came back to me today and asked me if I recalled what I did taking care of one of those patients, there were one or two that I could remember. The guy whose neck was sliced open by a piece of windshield glass, and I had to use my little finger to intubate his trachea. Yeah, I mean, there are certain things that I can remember like that. But the average run-of-the-mill patient, I'd have no clue unless I looked at the records. And then if I looked at the records, the only thing I'd be able to tell you, unless it, spawned a memory, was what's written in the record. So unless the record refreshed my recollection of it in that particular case, it wouldn't do much good to call me to come up and have me read the record into the record of the court. So I could testify what was written down, but that's it. And that's a problem many healthcare providers face when the documentation is less helpful than it should be. When I routinely did seminars for healthcare providers, I frequently told them that nobody ever got into court and said, "Gosh, I wish I hadn't written so much down." Usually just exactly the opposite. So in many respects, I thoroughly understood why Melton would not remember all of the smaller details that happened on that day, the day that his girlfriend was taken from him. Not to mention, there is a normal human tendency to move on, to try to bury the awful memories along with the body of the person who passed away. That may seem wrong, but again, there is a mental health aspect to that. Now, a lot of you, or I shouldn't say a lot, some of you certainly found the explanations made by Melton to be unbelievable, and you said you distrust him, and I understand that. You are exactly the juror that the defense is looking for, and I don't mean that in a negative way. I just mean the defense wants people to critically evaluate every piece of evidence in the trial, and especially testimony, and especially testimony that's coming from someone who is directly linked to the case. And they want people to go over and turn and twist and look at different ways to, see if the explanations may or may not make sense. But one of the comments really struck me, so I decided to do a little research and see what I could learn. Apparently, on day 2 of trial, the medical examiner testified. Now, trust me, you don't want me to play that video. The information that comes in there would violate, in most respects, YouTube's rules. You can find it in a number of different places on YouTube. But again, I would advise, unless you just happen to have a strong stomach, not to look at it. But a controversy arose about the chain of evidence of some of the DNA evidence. As you remember, the state is putting a lot of emphasis on that DNA evidence. Well, during my research on the case, I came across some facts which make me somewhat biased in favor of the state. I need to let you know that up front, because even though it should not matter and it should not ever be revealed to this jury, this is not Mr. Faust's first rodeo. In fact, Mr. Faust's DNA was in CODIS for a reason. CODIS, of course, is the national database where felony offenders have their DNA profile stored. The issue was whether the chain of custody was maintained in the collection and processing of the DNA samples taken during the autopsy. I'll let some of the video here speak for itself.
Let's talk a little bit about the swabs. I'm going to start with State's 25, which has been admitted into evidence. State's 25, what is that?
It's marked oral swabbings B.
Okay. And then just for clarification, State's 26. What are we looking at there?
This is marked oral swabbings A.
Dr. Falzon, I realize it's been a long time since this. Let me ask the question this way. Would you have collected 2 different sets of oral swabs back in 2001?
No.
What, if anything, can you attribute to the fact that 2 of those are labeled oral swabs and there is not one labeled vaginal swabs?
The swabs are collected during the course of the autopsy. As indicated in the report, I collected oral, anal, and vaginal swabs. Once the swabs are collected, as soon as they are removed, we take the swab tip and create the smear. So the swab is prepared, the smear is prepared, the smear is packaged. Because the swab is moist, if it is packaged right away, because of the moisture, mold grows on the tips of the cotton tips of the swabs. So the swabs have to be air dried prior to packaging. Every autopsy, the doctor has an assistant to help with the case. So the swabs would be placed in a small cabinet marked with the name, and it would be marked oral, anal, and vaginal. And the technician would package those swabs once they have air dried and packaged and labeled those.
Was that common policy and procedure at the crime lab back in 2001?
It was.
So the prosecution opened the door with what I believe was a pretty lame explanation for why there would be 2 sets of swabs that are identified as A and B instead of stating where they came from. But before he went into that explanation about the swabs, he indicated that the standard practice was to make the smears, and the smears are actually what the DNA, for the most part, is derived from. And the swab, although they are necessary for like backup testing, that sort of thing, if somebody wants to challenge the forensics and they want the actual swabs, they can get them. So, it does, in some respects, handcuff the defense if those swabs are mislabeled. And clearly here, the swabs were mislabeled, but the smears were not mislabeled. And that's the important thing to keep in mind here. So the defense attacks this in this manner.
On State's Exhibit 25 and State's Exhibit 26, and may I approach the witness, Your Honor? Just to refresh you on what those are. And you recognize these from direct examination, correct?
Correct.
Okay. You stated that the way that these are packaged, and please stop me at any time if I say it wrong, I just want to confirm that I heard you correctly, that you get a vaginal swab, you then make a smear out of it, but because mold may get on the swab if you leave it out, mold may get on the swab because it's wet, you leave it out to air dry, and then a technician would package it up later. Is that correct? Did I understand it correctly?
That's correct.
Okay. The question I have for you, does no one check the technician when he labels or she labels the items to ensure accuracy?
Not to my knowledge, no.
Okay. So, Dr. Falzone, is it possible I'll ask you this way. If no one checks, how do we ensure what's in either package?
It should have O, A, and V in front of each and every swab, the respective swab.
If it's checked.
Obviously, it wasn't done correctly in this case.
Correct. Are you aware that it is extremely important to collect and store swabs a certain way if DNA is involved?
Correct.
Okay. And is it fair to say that if it's done incorrectly, it could affect the results of any subsequent DNA testing of those items?
Absolutely.
Okay.
So now we have the medical examiner saying they were incorrectly done and that it can affect the reliability of the testing of those swabs. But he limited it to the swabs. So on redirect, the state had an opportunity to go back and see if they could sort of correct the record as to what the impact of having mislabeled swabs as opposed to mislabeled smears was. And it came in like this.
And then also on cross-examination, you were asked if the labeling of the items, the question that I heard was that the labeling affects the results of the DNA testing. My question to you, sir, is could the fact, think of the best way to ask this. Does the labeling itself, what is marked on a certain exhibit, have anything to do with the results of any testing of what is inside?
It would impact the interpretation of it.
So I'm just guessing here, but I don't think that's exactly what the prosecutor wanted the medical examiner to say. But I also suspect that it was due in large part to the prosecutor not understanding how DNA testing is done and the medical examiner not knowing where in the world the prosecutor was going with that question. So at the end of the day, I thought that the defense did a pretty remarkable job of slapping at that DNA and the swabs, even though the smears themselves were not affected by the mislabeling. So at some point, this comes before the judge.
Go ahead, sir.
We're moving to suppress the oral swabs due to chain of custody. In this case, it has been stated that oral swabs, vaginal swabs, and anal swabs were taken. we have the chain of custody report. The chain of custody report says that only 2 oral swabs were taken. I assumed that was pretty much an error on the chain of on the custodian, because Ms. Bigham, 2024, conducted a test on these swabs, and it was determined. They went to a company in California to do this test, and that's something we'll address on cross-examination instead of using the company here in Georgia. But that company came back and said, you know what? We did this presumptive test. These are actually vaginal swabs.
A couple of things here. One, if you file a motion to suppress, it has to be filed before you get into court, not, 2 days in, as this was. And his objection is really to the chain of custody and the fact that 2 of these swabs are mislabeled. And the problem for him is that his remedy, in terms of being able to do anything with these swabs, is limited now because he didn't file a proper motion to suppress before trial. They're limited to cross-examining the witnesses and creating doubt in that way. I'm not saying it quite as eloquently as the judge did. Here, let's let her explain it.
All right, let me stop you right there just for a moment. Is there any response to the motion to suppress as opposed to a motion in limine or an objection based on something else? Go ahead.
Yes, I would object to this being characterized as a motion to suppress. Mr. Cruz, we've had hearings going back for months. We've discussed making any physical evidence available to him to inspect, and we would have done so at any time. He never asked. He asked in court, but never followed up with that. This evidence we would have gladly shared with Mr. Cruz at any point had he actually asked, which he did not. I don't think what he's asking for this morning, well, again, I don't know a motion to suppress at this point. I don't know what legal grounds he's asking that it be suppressed. He mentioned chain of custody. I think that argument is more of a weight versus admissibility issue.
Let's discuss weight versus admissibility. A lot of times you have evidence that is not subject to a real objection as to it being hearsay or as it having been corrupted or falsified or some other technical thing where there's a reason why the court should keep it out of evidence. Seized inappropriately, for example. That would be a technical reason to keep it out of evidence. That's something you make before trial. But now he's saying, well, the chain of custody's messed up, so it shouldn't be admissible. But it doesn't go to admissibility. Chain of custody goes to the weight that the jury is able to give the evidence. In other words, is the jury apt to believe the explanation that the doctor offered for, hey, a dumb tech screwed it up? Or do they want to think about it as, gee, they are really trying hard to frame this guy, which I'm sure is what Mr. Cruz wants them to do. But he's got a problem in that with a weight versus admissibility issue, he isn't going to win on that. And he's not going to win on that on appeal. And he's especially got a problem here because there will be a sense of waiver. And by waiver, I mean, look, they've had all these hearings prior to the trial. Why didn't he move to suppress it back then? He's waived his argument as to admissibility. And that's what the prosecutor is trying to set up here. He's waived his argument to admissibility.
All right, Mr. Cruz, I'm going to overrule your objection, and I'm going to deny your motion, and I'm going to make the statement that the complaint that you're making in the form of an objection and the request to make a motion is certainly appropriately addressed by cross-examination. You have every right to cross-examine any witness with regard to chain of custody, with regard to the issues of tampering, anything that is relevant to the evidence that's being offered. You have every right to cross-examine with regard to those issues. And so that's the reason I'm denying your objection.
Now, that part of the hearing actually occurred before that evidence was discussed in court. And so you heard his cross-examination of the doctor about those swabs. The only thing he wanted to get in was, well, it could affect the results. And that was not, how do I want to put this? He did not nail the issue for the jury. What he should have done is he said, looking at this today, you can't tell me whether this is vaginal or oral, can you? And the doctor would have had to say, no, I can't. So if you can't tell and you were the person who did these, how is the jury supposed to know that these are even from this case? How do we know they're not from some other case? How do we know when they were collected? There's nothing on this label we can trust. And he should have he argued those questions with the witness. And he would have drawn objections, but again, the jury hears those objections and they wonder, oh, gee, what's the state trying to hide here? So one of the things I want to point out is his lack of experience is sort of showing here, but he is really trying his hardest to represent his client zealously within the bounds of the law. And he's also trying not to stomp on the judge's toes while he's doing it. But by telling the judge he's not trying to stomp on her toes, all he has managed to do is irritate the judge that much further. She rebuked him after that for saying that she extended him a courtesy earlier, when in fact the only courtesy she had extended him today was allowing him to be late because he'd apparently there had been a traffic issue or something. So it is funny to me how little he understands about how you deal with judges. You don't go up there and say, Judge, I'd like to make this objection, but I'm afraid you're going to be unfair to me. Well, you do that, you poison the well that you're going to drink from. And that's just not good trial strategy. His heart is in the right place. He's defending his client to the best of his ability, but he's focusing his anger in the wrong place. He needs to be looking inward. He should have challenged this evidence a long time ago on chain of custody grounds and moved to suppress it for that reason. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke. Get them a cup of coffee. Anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.